When a commercial tech firm like Stiletto IT installs a complex server system for a corporate client, the expectation of reliability is high. If that system catastrophically fails due to negligent installation, it brings the client's entire operation to a halt. Now consider a simultaneous failure. Stiletto IT completes a smart home network for a private homeowner, and it suffers an identical total system blackout. Both the corporation and the homeowner demand compensation. In response, Stiletto IT points to a single line buried in their paperwork, Clause 76, which states they accept zero liability for loss or damage, however caused. To determine if this clause can actually shield the company from responsibility, we have to subject it to a sequential legal stress test. This process moves through 4 stages: identifying the breach, confirming incorporation, interpreting the construction of the wording, and applying statutory controls. Analyzing the defense without first establishing the exact nature of the breach is a frequent error. Before we can test a defense, we have to isolate the specific obligation that was broken. Stiletto IT may argue they never explicitly promised the system would be reliable in writing. However, the law injects certain invisible obligations into every contract. Courts imply these terms to ensure business efficacy. In the 1889 case of the Moorcork, ship owners moored at a Thames wharf. The ship was damaged hitting the hard riverbed at low tide. Even though the contract was silent on the safety of the berth, the court implied a term that the wharf owner had taken reasonable care to ensure the spot was safe, as the contract wouldn't work commercially without it. Terms are also implied by the type of contract involved. In Liverpool City Council v. Irwin, tenants in these tower blocks withheld rent because the lifts and common areas were chronically broken. Because this was a standardized tenancy, the House of Lords ruled that a duty to take reasonable care of the common parts was a necessary implication of the landlord-tenant relationship. Whether they arise from commercial logic or the nature of the relationship, these implied terms carry the same legal weight as a signed written promise. In modern practice, most implied terms are established by statute. The applicable law depends entirely on who is buying, a business or a consumer. For our corporate client, the Supply of Goods and Services Act 1982 applies. Section 13 implies a term that the service is performed with reasonable care and skill. For the hardware itself, the Sale of Goods Act 1979, Section 14, mandates satisfactory quality. For the private homeowner, we look to the Consumer Rights Act 2015. Section 49 requires reasonable care and skill, and Section 9 guarantees that the goods provided are of satisfactory quality. In both scenarios, Stiletto IT's failure to provide a functional system establishes a clear breach of these statutory terms. With the liability confirmed, the focus shifts to whether the company can legally defend it. Identifying the correct statutory regime based on the parties' identities is the foundation of any valid contractual claim. A breach of contract does not always grant the right to end the agreement. The severity of the term dictates whether the victim can terminate the contract or is limited to seeking financial damages. Traditionally, terms were strictly labeled as either a condition, a major term going to the root of the contract, or a minor warranty. Only a breach of a condition allowed for termination. The case of Hong Kong Fur Shipping introduced a more flexible approach. A chartered vessel was out of service for 20 weeks for repairs. Rather than relying on a fixed label, the court looked at the actual effect of the breach. This created the innominate term. Instead of pre-classifying the term, the court asks, did the breach deprive the innocent party of substantially the whole benefit of the contract? In that case, 20 weeks out of a 2-year charter was not sufficient to allow termination. It is a common mistake to assume all statutory implied terms are automatic conditions.
In commercial contracts, the duty of reasonable care and skill under Section 13 is treated as an innominate term. Understanding this classification is the only way to determine if a client is legally entitled to walk away or remains bound by the agreement. Once the breach is established, the company must prove that their exemption clause was actually part of the contract. This is the stage of incorporation. The most straightforward method is incorporation by signature. Following Lestrange v. Graucub, signing a document binds a party to its terms, regardless of whether they were read or if the print was difficult to see. For unsigned documents, notice must be given before the contract is finalized. In Ollie v. Marlborough Court, a disclaimer seen only after entering the hotel bedroom was held ineffective because the contract had already been formed at the front desk. Onerous or unusual clauses require a higher standard of notice. In Interphoto v. Stiletto, a delivery note for photographic slides contained a massive late fee clause that the defendants didn't see. The court held that such a punishing term must be explicitly drawn to the party's attention. This is often called the red hand rule. The more unusual the clause, the more startling the notice must be to incorporate it. If the clause was never properly incorporated into the agreement, the company's defense fails before the court even interprets the text. Even if a clause is incorporated, the company must show that its specific wording covers the exact breach and damage that occurred. While courts interpret these clauses strictly, clear wording can exclude liability even for catastrophic events. In Photo Productions v. Securicor, a security guard started a fire that destroyed a warehouse. Because the exemption clause was drafted with total precision, it successfully protected the security firm from liability. However, any ambiguity triggers the contra preferentum rule. If the phrasing is unclear or open to multiple interpretations, the court will always resolve that ambiguity against the party trying to rely on the clause. Drafting precision is essential. At the common law stage, a single linguistic loophole can render a commercial shield useless. The final stage involves statutory controls. Even a perfectly drafted, incorporated clause must survive the Unfair Contract Terms Act 1977 for business deals, or the Consumer Rights Act 2015 for consumers. Under the Consumer Rights Act, liability for the main statutory rights, like satisfactory quality, cannot be excluded or restricted. For the homeowner, Stiletto's clause is automatically void. Business-to-business deals under UCTA are more complex. While a company can never exclude liability for death or injury caused by negligence, other exclusions are subject to a reasonableness test. Courts weigh the bargaining power, the availability of insurance, and if the client had options. The court evaluates whether the clause was a fair and reasonable one to include at the time the contract was made. Attempting to apply these business-focused reasonableness tests to a consumer contract is a fundamental error in legal analysis. The statutory divide is absolute. We can now resolve the Stiletto IT scenario by applying these stages to both the corporation and the homeowner. For the private homeowner is void, regardless of how it was drafted. For the corporate client, the clause was incorporated by signature, but it fails the UCTA reasonableness test. Because Stiletto used its superior bargaining power to impose standard terms, the court deems the exclusion unreasonable. Stiletto is liable in both cases. This methodology, mapping the breach, classifying its severity, testing incorporation, and applying statutory control, remains the standard approach for deconstructing any liability exclusion. Following this sequence ensures that no defense is ever analyzed in a vacuum, providing a predictable methodology for resolving even the most complex commercial disputes.